Her name is Lee Ann Walston, and she's joining us from 4kids4families. And what is your title officially again?
Regional manager.
Regional manager.
Yes.
So she's our guest speaker today, and she's going to be giving us, an insight into that world. So please help me welcome Lee Ann.
Thank you. All right. Thank you guys for having me. So like I said, I am the regional manager with 4kids4families. I cover adoptions in all 23 counties of Region 4. And then I also cover the permanency units of Gregg County, Rusk Panola, and Cherokee counties. I'm one of the 3 regional managers that we have. We are about to add a 4th regional manager, so there might be some structure changes, but of course we'll get that information out to all of you guys so that y'all are aware of that. So I've been speaking with Jared. He did ask me to come in today and provide information in regards to adoption and PCA, which PCA, I'm not sure if any of y'all are familiar with that, if y'all had a case that has gone through PCA, but PCA, it is our Permanency Care Assistance Program, and that is a program that we developed specifically for our kinship caregivers. So the difference between adoptions and PCA, adoptions, of course, is when we have parental rights terminated on both parents, then we always want to have adoptions as our primary goal. Adoptions is the most permanent legal outcome for a child. Otherwise, they would be an orphan without having any parental rights. So we always want to support adoptions, and that's always our goal when we have parental rights terminated. The PCA program was developed in those cases where we were getting PMC, but we did not have all parental rights terminated. It was a program that was developed to provide assistance to our relative and fictive kin caregivers so that they could be able to continue to provide for that child and meet their needs for however long that was going to consist of. It can last until they're 18. If for some reason the parents were to come back and try to go through the court system to get their children back because they'd made the necessary changes years down the road, then it would last until that was accomplished. But it was just something to be able to allow those relatives and fictive kin to provide for these kids so that they did not come back into the system, into foster care. So they are pretty similar in the benefits that they provide to the children. So I'm going to go over each of those and the qualifications so that way y'all have a better understanding, so that also y'all can kind of assist your caregivers if they have any questions as well. So first off, with the PCA program. With the PCA program, they have to be a relative or fictive kin caregiver, meaning that they have had a relationship with that child prior to them coming into CPS care. I know a lot of times we will get foster parents who ask if they can do the PCA program because we might not be able to get termination on that case. We cannot with the foster parents. They, again, have to have a prior relationship with that child before they came into CPS care and custody. The other one is that the home has to be a verified foster home. So that relative or fictive kin has to become licensed as a foster home, and that child has to be placed in that home as a foster child. They do have to be placed in the home as a foster child for 6 months before they can get PMC transferred to them and do the PCA program. The other thing is that parents cannot have or get JMC of the child. That will disqualify them from being eligible for the PCA program. So the parents, they can only have possessory, and then the department has what's called PMC, permanent managing conservatorship. Does that make sense? So with that being said, once we get PMC, again, the child has to be in the home for 6 months before we can transfer PMC to that relative and fully get out of the case. That allows us the time to complete all of the necessary paperwork, negotiations, everything we need to get the family qualified for the PCA benefits. Now, the PCA benefits, again, are just like adoption benefits. They're pretty much the same. They will get a financial monthly subsidy payment of between $400 to $545 a month for that child until they're 18. That will, of course, depend on the child's what we call level of care. So basically, if they are a child who has a lot of needs, and so they have a higher level of care, we'll get them leveled higher to where they'll get the 545, the maximum amount. They will also qualify for Medicaid, which will help assist in covering all of their medical costs, dental, therapy services, things like that, to be able to continue taking care of them. They will qualify for the tuition waiver program. So if they decide to go to a Texas state funded school, they will get their tuition fees waived. The other thing that they will qualify is for a non-reoccurring expense. This is basically any expenses that caregiver had to come out of pocket for during the process of getting licensed, anything like that. If they would keep all of their receipts, they will actually get reimbursed for those. It's a non-recurring expense that they will complete a form, send in their receipts, and they will get refunded for that. So sometimes we have the caregivers come out of pocket for what's called FBI fingerprints, which they're required to do to become licensed. So they could get reimbursed for that cost. Sometimes if they have to pay out of pocket to get certain things completed in their home to make them eligible to be licensed as a foster home. So maybe adding smoke detectors, having to go and pay for a fire extinguisher, things like that. If they keep their receipts, they will get reimbursed. So that's part of that non-reoccurring expense that's set aside to help basically reimburse them for any expenses they had to pay out of pocket to become licensed in order to qualify for the PCA program. Now, these benefits will continue with that child until they turn 18. If we do have a child who is about to turn 16 and we're looking at the PCA program, if they qualify and we do the PMC when they turn 16, they can actually qualify for the extended PCA program, which will actually last until they're 21. Of course, there is criteria for that to continue those payments to help the caregiver. They would have to either be enrolled in school full-time, or they will have to have a part-time job equaling up to 80 hours a month. So roughly 20 hours a week that they would need to be working. Or they would have to have a letter from their physician stating that they may have like a physical condition that does not allow them to work, if that makes sense. The other thing with the PCA benefits, if the child is receiving SSI, so if they already qualify for Social Security disability, then it is a federal funded program, just like our program. So you can only receive one or the other. So if they are already qualified for Social Security disability, then they will usually get the Social Security disability and not our PCA subsidy payments, because a lot of times the Social Security disability is more than what our PCA is. And so they'll usually get that versus ours. Now, if for some reason they were no longer qualifying for the Social Security disability, then of course they could contact the eligibility worker and get the payment started for the PCA subsidy. But with that being said, they will still get all the other benefits. Of course, with Social Security disability, they're usually already qualified for Medicaid. So they'll continue receiving Medicaid through the SSI disability, but they'll still get the non-recurring expenses, the tuition waiver, all of those things with the PCA. Okay.
Yeah.
Yes.
I have a quick
Yes.
question from
Yes.
the chat. Also, this is a lot of great information.
No,
Thank
no.
you. So, and this is kind of in the same vein of what you were already talking about, but is there an income limit of for the family to qualify for these benefits?
Not necessarily. Our negotiator is pretty good, unless they're just like a doctor and making a substantial amount of money. A lot of times we are able to get them qualified. So we have had some relatives that make a pretty good amount of money that are still being qualified for it.
Okay.
Mm-hmm. So our negotiator works with them to try to get them qualified, just because it's just an added benefit, because we all know how much it costs to raise children nowadays, especially with all the extracurricular activities. So, yeah, our negotiator is really good. Unless they just make an astronomical amount, then usually they more than likely will qualify.
Okay,
Mhm.
perfect, thank you.
The other thing is, that goes along with Social Security is the, RSDI. So, RSDI is basically Social Security death benefit. So if they had a parent who passed away and they worked a certain amount of time during their lifetime, then that child will qualify for those death benefits. And that goes along with adoption subsidy. The RSDI, it doesn't matter if their rights are terminated or not, that stays with that child. And so if they get the RSDI payments because of a parent's death, they will still get the PCA subsidy payments. So RSDI is different from Social Security disability. It does not, it's not taken away, or it's not the only thing that's provided to them like Social Security disability. It's a different type of benefit. So if a child gets RSDI, they can also receive the PCA eligibility every month on top of the RSDI payments. So that's just kind of an added benefit for that child. Yes, sir.
A question to clarify. So if a child is eligible to receive a benefit either from Social Security or even the teacher retirement system because of the death of a parent, while they're underage, does the state take those funds, or is that the child's funds?
So yes, when they're in our custody, the Social Security disability, any of those Social Security funds, they do come to the state, but they're usually put into a savings account for that person. Now, those funds can be released to a relative or fictive kin caregiver, even if the child's in foster care. We just have to fill out a form to, express what the need is. So if a child has a need, I know we've done it for braces, like after we've exhausted all of our efforts with Medicaid, because sometimes Medicaid is very finicky in removing braces. So we've just got to show that we've done our part in trying to provide for that outside of using that fundage, and that there is a need for it. And then we just fill out the form. We submit it to our Social Security liaison with the department. So we have one that covers Region 4 and 5. Her name is Shasta. And so we would just send it to her. She would review everything, make sure everything looks correct, and then she'd be able to process that and release those funds to that caregiver in order to pay for whatever they needed.
Okay, so the funds are held in trust for the
Yes.
child, and I guess if they age out of the system, is that refunded to the child?
Yes. Yeah, or if they get adopted, or if they get, like I said, PMC to a relative or PCA or whatever, then it will get released to that caregiver. Now, the process that has to happen is that caregiver, once they adopt or once they take PMC of the child, then they have to go over with the certified order of either adoption or PMC to the Social Security office and file as their payee. And that's how it gets transferred. Yes. All right. So with PCA, like I said, a lot of times those are cases where we're not able to get PMs, or we're not able to get PMC with termination. So we're not able to terminate the parental rights. It could be that we're able to terminate dad's rights, but we can terminate mom's. Or I've seen cases where parents did just enough, but they're still in an unsafe situation. They may be trying to find housing, things like that. We're at the end of our case and we can't terminate, but we can do the PMC, where we get PMC and we work towards getting custody to a relative. Those are why we developed this program of the PCA, because we wanted to help these caregivers out, because these cases can't be prolonged forever. So those are really the only times that we like to use the PCA program. Very rarely have I approved it for cases where children's parental rights have been terminated. The reason why is because there's a new law where parents after 2 years can petition the court to get their rights reinstated. So it kind of leaves that child vulnerable to where the parents could come back and take custody over of those children. So, and plus also legally, I mean, adoption is the best outcome for a child. It gives them a parent, and it gives them that family. So with adoptions, the qualifications for adoptions is that they have to be a Caucasian child, age 6 or older, or they have to be a child of a different ethnicity or race. So it could be a white child who is also Hispanic, that would qualify them. And they would have to be 2 or older. So if they are of a different ethnicity or race and are 2 and older, they automatically qualify. Or if they are a Caucasian child, full Caucasian, 6 years or older. The other qualifications is if it's a sibling group. So if it is a sibling group that's being adopted together, or if a sibling has previously been adopted. So for instance, if you have a child that was adopted and then mom had another child, that child went into that same home where that sibling was already adopted, and they adopted that sibling through the state, through another CPS case. Since that family already adopted a sibling through a CPS case, then they would qualify because now they are adopting that child's or the child that they adopted on its own. They're now adopting that sibling. Does that make sense? So the other qualification is they have to have what's called a handicapping condition. We have to have a letter from a professional is what they say, but it basically has to be a professional that can make diagnoses. So it could be a psychiatrist, it could be a neurologist, a primary care physician, but it has to be somebody that is qualified to make diagnoses. So with the handicapping letter, because that's where a lot of our Caucasian kids who may have been exposed to drugs, but they're still under that 6-year-old, mark. That's where a lot of times we'll look at what kind of things they've been diagnosed to see if it might qualify as what is considered a handicapping condition to get them eligible for adoption assistance. So that could be that they were exposed in utero and they've been having some issues, maybe some developmental delays that they've been receiving some therapy for. I've had children who have had asthma who have qualified. It's really up to that doctor if they're willing to write a letter that just states that the child has this diagnosis and it is considered a handicapping condition. So it has to have those things, and it has the child's name, date of birth, the diagnoses, and that it is a handicapping condition. So it can't say it can be a handicapping condition. It has to say it is and that's what we use to be able to qualify them. I know that our adoption workers do have some letters to explain what it's needed for, which helps doctors understand that we're not trying to use it to get the child qualified for disability or anything like that. We are strictly using it in order to qualify them for adoption assistance in order to help that family long-term to be able to provide for the needs of the child. Because what we've seen a lot of times is we do have children who have been exposed in utero to methamphetamines. And because the chemical makeup of those drugs are forever changing, we never know how that child's going to be affected long-term. They could have neurological issues later on in life, develop seizure disorders. Once they hit puberty, there's so many things that can happen. So even though a family might not qualify and they might not get that handicapping letter, we always complete the adoption subsidy packet regardless, because if they're denied, it puts them in the system. So if, for instance, something happens later on, they are diagnosed with something that qualifies them, then that family can request to relook at the subsidy and have them requalify for subsidy. So that is something that even though they could have adopted the child when they were a year old, and now they're 14 and they have a medical condition that qualifies them, they will still be able to reach out to that eligibility worker and ask them to requalify, and they'll submit their paperwork, the handicapping letter from the doctor, and they could qualify later on for subsidy, and they would be able to get those payments and that Medicaid to help out with that child's needs. Okay. The other thing with adoptions, the child has to be in the home for 6 months. I know that gets confused a lot of times because sometimes you'll have CPAs tell the caregivers, oh, you have to be licensed. The child has to be in your home as a licensed caregiver for 6 months. That is not true. We look at it as the child has to be in the home, whether it be a fictive kin, relative placement, they have to be in the home for 6 months. They do not have to be licensed and in the home for 6 months for relatives and fictive kins. I think that's a lot of mix up that happens, especially with CPAs who are working with the family to get them licensed. The reason that we do 6 months, it's more or less for our recruitment cases. So cases where the children are not in their permanent placement and we find them an adoptive home. We make that match, we place the children in the home. 6 months is kind of like a good window to where we can really see how that child's going to do and if that family can meet their needs. Because we all know kids, they get in a home, they'll have the honeymoon period. That honeymoon period could be a day, it could be 2 weeks, it could be 2 months. It really kind of just depends on that child. Every child's different. So the studies that were done showed that that 6 months is a good time frame for them to really see how it's going to be to take care of that child and to meet their needs and to know if it's a right fit. So that way it gives them time to know if they're going to be able to take care of that child long term. So that's why we do the 6 months. The other thing for adoptions is, of course, the caregiver has to be licensed. They could be licensed to adopt, or they could be licensed as foster adopt. That's more or less for our relative caregivers. If it's foster homes, we already know that they're licensed. If they're licensed just as foster and the case goes to termination, they want to adopt, it's not much for them to update their license for adoptions. But for relatives, they can either be licensed for foster adopt or adopt only. The difference is with foster adopt, there is a lot more classes. There's a lot more that they look at in the home for fostering, because usually when they're looking at licensing a home for foster, they're looking at ages birth to 17. So if they're only licensing the home for adoptions, which a lot of times that's what we want, because they only have to be licensed to adopt, they're looking at that child specifically. So say if you have a 15-year-old in the home, they're not going to have the child safety locks, the child proofing with the plug covers, things like that. They're not going to have to meet those requirements of the licensing. So it's a little bit less when you're just getting licensed for adoption. So a lot of times we'll encourage the family just to be licensed for adoptions unless they're wanting to look at fostering in the future, which we encourage because we need more foster parents. The other thing with adoptions is there is what's called a 90-day post-termination legal timeframe that we have to wait for. I know a lot of these judges, once we get termination, they want that case over to adoptions, and they want that child adopted immediately. Unfortunately, we have to wait a 90-day legal timeframe, because that allows for, if the parents are going to appeal the decision, or if you have family that is going to come in and file to intervene, we have to give them that allotted time if they're going to do that. Now, I know that there is some confusion with that, because the Texas Family Code is really not specific when that 90 days starts. Some adoption attorneys will do it 90 days from the hearing. I know some of y'all might be familiar with Beverly Bass. She is one of the adoption attorneys that does a lot of the adoptions in our area and in Region 5. She is very big on making sure she does everything by the book. She doesn't want anything messed up, which we appreciate. But with her, she will only do the 90 days from the day the judge signed the termination order. That's where her 90 days starts, because again, it's very gray area with Texas Family Code, the law that says 90 days post termination. It says from rendering of the decision. So that could be the day that we had court and the decision was made by the judge, or it could be the day that the judge signed it. Everybody interprets that differently, but she always kind of does that CYA and does the safest option and going by the date that the judge signed that order. So that's why it's so important that we tell our permanency staff, make sure that your legal team has got that order to the judge, make sure he's getting it signed as soon as possible so it doesn't prolong that, okay? The other thing with adoptions is they have to be able to review what's called the HESIC, which is the Health, Social, Education, and Genetic History Report for the child, as well as the redacted case record. That is law. We have to be able to provide that information to any caregiver that is adopting a child, so that way they have all that information. They know all the history of that child. Because if you think about it, when you go to a doctor's office with your child, what's the first thing they ask? Is there any history of heart disease? Is there any history of cancer? So that's what allows us to provide that family that information, so they know the history of that child. They know everything that's kind of happened to that child, and they know that they're able to care for that child long term. We have to provide that before any adoption. Now with the HESIC, we do not have to provide a HESIC report if it is first generation relative. So meaning aunt, uncle, adult sibling, or a grandparent. That is what we consider first generation relative. If it's a great aunt, great grandparent, cousin, anybody like that, that is second generation or further, then we do have to provide them that HESIC report. Okay. Again, some of the benefits of adoption is the same as the PCA program. They will get the monthly adoption subsidy payments of up to $400 to $545, depending on the child's level of care. So basic is up to $400, and then anything above basic, which is like moderate care. I'm not sure if y'all heard of the LFCs, the level of care program. We still do them in adoptions. They are kind of transitioning those, but we still do them just to identify where that child is, if they have higher needs and need a higher adoption assistance every month. But so moderate or above will get the $545 monthly until they're 18, unless they were adopted at the age of 16, then they'll qualify for that extended adoption subsidy, which could be provided until they're 21. If the child, again, after they graduate from high school, if they're attending school full-time, able to work at least 80 hours a month, or if they have a letter from their doctor stating that they are not able to work or attend school based on medical issues or anything like that. And then with that, you get the Medicaid that they will be provided until they're 18. They will also get the tuition fee waiver for any Texas state funded school. And then they will get the non-reoccurring expense. With adoptions, the non-reoccurring expense is a little bit different because what that does is it pays for the adoption. So it pays for the attorney fees, it pays for the court filing fees, pays for the new birth certificate. So anything that encompasses what it will cost for that adoption, that non-reoccurring expense will pay for that. Now, with that being said, a lot of times the caregivers don't see that, because if they get an adoption attorney that is used to doing adoptions with CPS, they take care of that kind of to the side. So it's up to, I believe, $1,200. I think it's been that same amount. But it's $1,200, and that just basically pays for the adoption of that child. Same thing with SSI and RSDI. If they do receive a Social Security disability, they will get that instead of their subsidy payments. Because again, a lot of times that's a higher payment than the subsidy. If they get RSDI, they will receive the subsidy payment plus the RSDI death benefits from Social Security. And like I said before, it doesn't matter that their parents' rights were terminated. They will still get that if they have a parent that passed away and were already qualified for that. Okay. And actually I've had a child who rights were terminated, but dad passed away right after, and we were still able to, submit for RSDI. They approved it even though rights were terminated, and that child was still able to receive RSDI payments until they were 18. So it's just an added benefit that can help that child out, because when they turn 16, they're going to need a car. So that was kind of what that adopted parents were going to use that for. They were going to put it aside. So that way that child had everything they needed as they aged. If they wanted to be in cheerleading and dance, anything like that, they wanted to make sure that that child had everything they needed and could do everything they wanted to in life. So that's kind of what they were going to be using that for. Talked about recruitment. Now, some of the barriers that we have, because again, I know a lot of times when we get termination, we want that case to go to adoptions immediately and start getting that adoption completed. So some of the barriers that we have with the adoptions is, of course, getting that case transferred from permanency. So as soon as they get termination, they will submit a form to our adoption mailbox to request to be put on the adoption transfer staffing list. That will be the month following the termination. They will staff that case. If there's anything needed on that case, they will usually notify the permanency worker. The permanency worker has until the end of that month to get all that stuff updated in order to transfer it to adoptions. One of the things why we do that is because, again, the requirements by law are that we are to provide the family with a redacted case record. It's the entire case record. meaning that we have to have everything that's gone on in that case in that record for them to review before they adopt. So a lot of times the issues that we run into is that there's things missing that the workers have to put in there before they can request the redaction, because it has to be the entire case, from start to finish, everything that went on in that case that needs to be redacted. When I say redacted, that means that we're taking the reporter's information out, we're taking social security numbers out, other identifying information that is considered confidential. So stuff like that is what's being taken out of the redacted or the record, so that way they're not provided confidential information. Does that make sense? But everything else is in there. The reasons why the child was removed, psychologicals that the parents might have completed. That way it gives them insight of any diagnoses that the parents were provided during the case. It has all that kind of information, so that way the family knows exactly the family's history and what happened to this child. Okay. The other thing is HESICs. We've really kind of worked on getting HESICs updated. Usually HESICs take about 45 days to complete, so we haven't really had any problems with that. Our biggest issue is redactions. Redactions are sent to state office, and that's who redacts that record and gets it back to us. It's supposed to only take 60 to 90 days to get a case redacted, but there are times that they have been backlogged because they do redactions for the whole state of Texas for CPS. So we do have some instances where we've had issues with those being backlogged. So that's one barrier sometimes that we have in moving forward with adoption if we don't have that back. But I know my workers are pretty good on staying on top of that. They usually will email the redaction mailbox to get a specific date on when it's due back, and they will continuously follow up on that. Because I know my expectations for my area, for this region, is 90 days. I want adoptions. If there are no issues and no concerns, that child's where they need to be, the family's ready, the child's ready for the adoption, there are no safety concerns, then I would like for the adoption to occur in 90 days, because that's the post-termination time frame. So we can get everything done within that time frame to be able to get that adoption consummated in 90 days. The other barriers that we have are appeals. Of course, if a parent does appeal a case, we cannot move forward until we have that mandate from that decision of the appeal. And of course, that can take 6 months to a year. It really just depends. There is a website that everyone can go on to follow that appeal. It's something that I can email to you, Jared, that you can provide everybody. I've provided to my staff. I tell my staff, give it to your CASA, give it to your caregivers, because y'all are our feet on the ground sometimes that really help us. Because I know I've had some CASAs, they are refreshing that every day, checking on it, and it helps us because y'all can give us an update faster sometimes. But there is a website that you can go on to. It's the Texas Appeals Court. You can search any case. You just have to have the termination cause number, which y'all already have that because y'all do your court reports. So you can follow that to see when things are being filed, when, decisions are being made, everything. Once the appeals court makes a decision, they usually set a date for the mandate to be returned. And we tell the workers, once you have that and you know that that's the date that it's supposed to be returned, like a decision's been made, you're just waiting on that mandate, go ahead. Go ahead and send your form over to the adoptions mailbox so we can go ahead and staff it. That way we're getting that case moved over as soon as we get that mandate back. But that's one thing that does sometimes hold up our cases. And the reason we do not take cases on appeals is because it's just too confusing for that worker. We don't want to sit here or for that child, I'm sorry. We don't want to sit here and transfer a case to a brand new worker. And then if the appeal is, overturned and the child's going to be, going back to the parent, or they're going to be reworking services with that parent, then you have to transfer that case back to a permanency worker. So they would just be moving from worker to worker. And we don't want that disrupt for that child. We would rather keep them with their same worker while we're, going through the appeals process. So that way, and plus if it's an older child, they're not dumb. They know what adoptions is. They know what it means. And so a lot of times they're getting excited about adoptions. And so when you have an adoption worker come and seeing you, and then that appeal comes back and they've overturned the decision, it's just devastating for that child. So we don't like to transfer it to adoptions until we have that decision of the appeal. So that way we know that we are going towards adoptions and we can go full force and get that child adopted and in their permanent placement. The other issue that we have a lot of times that's a barrier to adoptions is either the child or the family's wavering on that decision for adoptions. I know that we have a lot of teenagers who have been in care for years and years and years. I personally do not allow my staff to change the plan from adoption to independent living or anything like that until we've exhausted everything. I want the child in counseling. I want us having open conversations, because if you think about it, the child, a lot of our teenagers they say they don't want to be adopted, but deep down inside, they truly want a family. They want a mom and dad. They want to have that family. They want to have somewhere to go for Christmas and Thanksgiving. But a lot of times they've been rejected so much time and time and time again that they would rather reject it first than to have somebody reject them. And so I do not allow them to change the plan until we have thoroughly addressed it in therapy. We've done everything we can. We do have 2 recruitment adoption workers. Those are the workers who are assigned secondary, who are doing recruitment efforts on these kids. And then I'm sure some of y'all have probably talked to our CFE team. It is the Wendy's recruitment workers. This is a new program that 4Kids has received a grant to start, and I'm sure that we're going to continue the program. I worked with the first pilot Wendy's recruitment program in Region 7 in the Austin area, and it is a great program. It really is. It's kind of a program that thinks outside the box. But we do have adoption recruitment workers and those Wendy's recruitment workers, and they work hand in hand. Their goal is to try to find permanency for these teenagers. And so that's why I never discount taking adoptions off of their permanency goal, because they really want a family. And a lot of times they're saying no to adoptions because they don't want to be rejected. There's been lots of times where we have found a family, and we have slowly presented that family to that teenager. We've kind of let them set the pace on how we do visits, how we do introductions, stuff like that. And we've had it work out really well. And then that child gets adopted. So that child that did not want to be adopted then changes their mind and they want to be adopted. We are going to continue the match events. We are looking at having one in either April or June in Longview, and then we will have another one in the fall in October. But that's another way that we bring our teenagers out and try to get them to meet families, because that is, I know several match events that we have had kids who did not want to go. They did not think they were going to have fun. They thought it was going to be a waste of time, and then they ended up finding their forever families. Because it just brings those families and those teenagers together so that they can kind of see that child, because it's different reading about them on the TARE website, on a profile page or whatnot, than meeting them in person and getting to see their personality, getting to talk to them about their interests and seeing them light up, getting to talk to them about what they want to do in the future. So those match events are very crucial, especially for our teenagers, to kind of get them out there and meeting families so that they get to see them in their true element and how they really are, and not reading them on a piece of paper and not getting to really know the true, person. So we will continue those match events because we want to try to get these kids permanency. That is our biggest push and goal, is to try to get these teenagers who have been in care for years and years and years into a permanent situation. That's all any other barriers that I didn't bring up, April? Okay, that's pretty much all of it. I know I talked to Jared. I know there's probably going to be questions. A lot of times you guys have case by case questions because every case is different. You could have cases come in for the same removal reason that you had a case just, 2 years ago, but it's going to be totally different from the way you worked that case. So I know a lot of y'all probably have questions on case by case basis. Maybe y'all have something going on with a caregiver during their licensing process that y'all might have a question about. So do y'all have any questions?
I have one question.
Yes,
It's not necessarily related to that, just clarification on the benefits that a child might be entitled to through Social Security or TRS system or something like that. Whether the parent is either deceased or still living, possibly, but are receiving disability benefits, which would entitle the child to disability benefits, or they're simply at retirement age and have legal custody and are the legal parent for a child. They're just at retirement age, so the child is entitled to a portion of Social Security payments or teacher retirement system payment. And those rights for that parent are terminated. The child does not lose any of those rights to those Social Security or teacher retirement system benefits that they were entitled to before the parents' rights were terminated. Is that correct?
So RSDI for sure, yes. I would have to check on the teacher retirement benefits. We've never really encountered anything like that. I think because our demographic of parents is a little bit different. So I would have to check on that teacher retirement stuff. That may be different since the parental rights are terminated. Now, if it was like a PCA situation where we weren't terminating the parental rights, they would still have what's called possessory rights. So they would still have basically their parental rights intact. So they would still qualify under that. But if it's an adoption situation where the rights have been terminated, I do not think that they will continue with those, the teacher's retirement, any of that for that child, because yeah, the parents' rights are terminated. The only thing that we have seen that they continue to get is that RSDI. If that helps.
So in the PCA, then the parents still have parental rights, or?
So on most PCAs that we do, again, because if we have parental rights terminated, our goal is always going to be adoptions. Because you're looking at kids who have no parental rights. So they're considered basically orphans. And so we always want to have adoptions. The only time that we would approve for PCA for a child who has parental rights terminated is, for instance, say if it is a relative adopting and the child just does not want to be adopted. They're a teenager. They have been through therapy. We've done everything we can to discuss adoptions with them, and they are just dead set that they do not want to be adopted. In those situations, we would, of course, have a meeting and discuss it and make sure that everybody, including CASA, Attorney at Law, everybody's on the same page and agreeing to go ahead and let them do PCA, because we don't want to keep them in care. We want to give them normalcy, let them, be out of foster care. And in that home setting where we're not coming out every month and visiting and disrupting them. But we want to make sure that we've exhausted everything. So we want to make sure we've talked to them. We've had the therapist really discuss the differences of adoption and just PMC, things like that. Because you still run into issues if there's no rights, if all rights are terminated and that relative's just getting PMC, they're just permanent managing conservatorship. So it's going to be difficult for them to get a passport. They're going to run into some issues when they're filling out the college, forms and stuff like that before the child turns 18. So there's a lot of issues that they're going to run into only having what's called permanent managing conservatorship and not actually being the legal parent.
And so what do you mean by possessory? Does that apply to that family that has a child in their possession?
So possessory rights are only when we do not terminate parental rights. So if you have a case where we were granted permanent managing conservatorship, like we ran out the legal time frame of TMC, temporary managing conservatorship, we're at the end of the case, we either have to terminate or we have to do PMC. If we do PMC without terminating the parental rights, then parents are usually what's considered possessory. They have possessory rights, meaning that they have the right to get updated on their medicals, their school, all that stuff. They have the right to be notified of any of those changes for that child.
I caught that in time. We almost had cat trumpets playing. Next video. Okay, so somebody did ask this in the chat. So once an adoption is finalized, if a family moves to a different state, are they still eligible for the same benefits, such as free college?
So yes, but it has to be a state of Texas funded school.
Okay.
Meaning that the state of Texas has to fund that school. Now, they have made some changes to those qualifications. I know in the past, they couldn't get like a trade school, such as like cosmetology, massage therapy, some of these boys who are going into like mechanic, trade schools, things like that. A long time ago, we couldn't get those approved because some of those were private. They were not state funded, but here in the last several years, we have been able to get those approved. So it really is just one of those that they want to go ahead and call, because they will be giving, when they get adopted, they sign an adoption agreement. And that will have the contact information for their eligibility worker, who basically is who they contact if they have any issues with their payments, if they have any issues with Medicaid, if they have any issues with, moving and needing to update their address, anything like that, they have that person's number, and that number is tied to an office that will always have that position. So if they have any changes, they can always call that. They will connect them to the right person to make sure they get the college information. They get the forms to fill out for the tuition fee waivers and all that stuff. But yes, it's typically supposed to be a state of Texas funded school. Mm-hmm. But you also want to make sure that they're filling out the FAFSA. When they fill out the FAFSA, it does have a question. It's a question that says, I think if they've ever been in the custody of the state or something like that. But if they check that box, a lot of times that will qualify them for certain grants and things like that. So even if they're going to a private school, say Baylor, TCU, anything like that, that's not state funded. If they fill out their FAFSA, it kind of opens the door, since they have been in foster care and adopted through foster care, it opens the door to some grants that are specifically set aside for those children.
Okay. Thank you.
Going in a different direction, you mentioned that law about parents who've been terminated after 2 years, they could petition the court. What's been your experience with that, or has that happened?
Yes, we have. Now, they do have to prove that they are safe. They've alleviated any of the concerns that were involved in their case with CPS. They have to prove to that judge that they are a safe option for those kids to return to. But yes, we have. We've seen some parents that have come back.
From Region 2,
Mhm.
and 2 of my cases that happened, one complete success, other one horrid.
Yes.
And so I just wondered if there was sort of an overarching, what does this look like? Has it been used a lot? Has this ended in success, or?
I don't see it as much because because these parents, of course, have to have the money to be able to afford an attorney, afford the court fees and all that stuff. So a lot of times you don't see it because a lot of parents can't afford those. I've seen it, just like I said, I've probably only seen it less than a handful of times happen since that law went into effect. And that's, of course, across the whole region of 23 counties. So it hasn't really happened a lot. But again, it's also dependent on that judge. I mean, if y'all been in front of different judges, judges vary. You have some that they're not going to. But then you have some that are more lenient that, they will approve it. So, yeah.
Does the same rule apply on that same situation if the rights were terminated versus voluntarily terminated?
So that's a good question. So when they relinquish their parental rights, that is irrevocable, but they still can try. But again, if they are adopted, that squashes all of that. So if the child is adopted, then that adoption, they are not able to come back and try to get their parental rights or anything. It's only when they have PMC. So only if it's a case where we have PMC and not adoptions. So like if they voluntarily relinquish their rights, we terminate it, and then that child goes to a relative, and the relative's just like, I don't want to adopt, I only want PMC, and say, even against our recommendations, the judge orders PMC to that relative, then they're putting themselves in a position where that parent can try to come back and reinstate their rights, even with the relinquishment. But they are supposed to be irrevocable, but again, it really kind of depends on your judge. Any more questions?
It's not yet in the chat.
Yes, ma'am.
When you were talking about Caucasian, age 6 or greater, what's the difference between those two ages? One was 6 years old, and then if they were of a different ethnicity or race.
That's just the qualifications for adoption subsidy. The reason that they did that is that we were seeing a lot of disproportionality in the system where you had a lot of children who were of different ethnicities and races that were not being adopted as quickly as Caucasian children. And so that's why they set that qualification up to where it would try to get our children of different ethnicities and races adopted, because we were having children that were staying in care for years and years and years. And so, yes, they have to be, if they're Caucasian, 6 or older, and it's just a single child. If it's a sibling group, none of that matters. The 2, 6-year-old, it does not matter. If it's a sibling group, they're automatically going to qualify. Or if that child is being adopted into a home that previously adopted their older sibling, then that would, that doesn't matter. It's either sibling group or one of those things. If it's a single child, it has to be Caucasian, 6 or older, or of a different race or ethnicity, and 2 and older.
So it's basically just giving a monetary incentive. Wow.
Well, we don't have any more questions in the chat. So, do we have any more questions here in the room?
Great information.
Yes. And like I said, if you have any questions, I do have one of my adoption supervisors, April Pride. She came, I just wanted for you guys to meet her, put kind of a face to the name. She covers, so I have 2 adoption supervisors. April's one of them, and then Rosalind can too. She's in staffing, so she couldn't be here. But they are the ones who cover the whole region. April covers, so if you look at a regional map, if you look at I-20 kind of splits it from north and south. So April covers all of the southern counties, but also including Harrison, which is Marshall. And then Rosalind will cover all of the northern counties. So I know for Van Zandt Smith, if you're CASA with Van Zandt Smith, then April is the adoption supervisor for those 2 counties. And then Wood County, it would be Rosalind Cantu, who's the adoption supervisor. So if y'all ever have questions, y'all can always reach out to one of them or myself.
Thank you.
No problem. And yes, no problem. When I send you the information for the appeals court website to provide to all your CASA volunteers and supervisors, I'll also give you our information for Rosalind and myself and April. So that way we can disperse it to you guys. So if y'all need anything, y'all can reach out to us.
That would
Okay.
be perfect.
All right.
Thank you so much. Yeah,
Thank you.
absolutely. Thank you all so much for being here today. And so I just passed out those surveys, and if you'll just leave those over here with Lee before you head out today, we would greatly appreciate it.